The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon, and welcome to Counsel and to those who are watching on our Supreme Court Live channel. I would ask Mr. Doug Shima, the Clerk of the Appellate Court, to please call this afternoon's docket.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Tuesday, March 30th, 2021 consists of one case. Appeal number 122348, State of Kansas versus Christopher C. Harris. Shawnee County briefs both sides. The appellant has 2 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
Yes, may it please the court, Deborah Wilson, Capital and Conflicts Appellate Defender, appears on behalf of the defendant, appellant Christopher Harris, ready for argument.
May it please the court, the state appears by Deputy Solicitor General Chris Elslager, present and ready for argument.
Thank you, counsel. Ms. Wilson, you may begin your argument.
Thank you. Mr. Harris was convicted of attempted capital murder, aggravated robbery, assault with a deadly weapon, and criminal possession of firearm following a jury trial in Shawnee County, Kansas. He was accused of robbing a Topeka convenience store at gunpoint and later shooting and wounding a law enforcement officer. Following his convictions, he was sentenced to a sentence of life imprisonment plus 273 months, and this is his direct appeal. The attempted capital murder conviction in this case is based on the shooting of Topeka Police Department Detective Brian Hill while Detective Hill was on duty. There were probably security measures in place throughout this trial, but they must have been unobtrusive because defense counsel had no complaints. Likewise, it doesn't appear that there was a large contingent of law enforcement officers watching the testimony as the trial unfolded. However, right before the instructions and right before final arguments in this case, 15 to 20 police officers, all armed with their service revolvers, all wearing badges, some in uniform, some in non-uniform work clothes, entered the courtroom together and took seats behind the prosecution. We work from a cold record, but you can almost hear the exasperation in the trial court's voice when the court, as this happened, when the court observed, "Counsel, it's too much," and observed, "They're filling half the courtroom." And when defense counsel said, "It's obvious what's going on here," the trial court replied, "I know." But as defense counsel sought to address this prejudicial conduct, the trial court was already expressing doubts that the effect of the appearance of the police officers as a group could be reversed. The trial court stated, kind of thinking out loud, "The jury has already seen this. Do I compromise the defendant's rights more by asking the police officers to leave at this point?" We essentially agree that at this point it was impossible to proceed, and we contend that the trial court's failure to declare a mistrial due to this fundamental failure in the proceedings was an abuse of discretion.
Do you see, Ms. Wilson, do you see a difference in what happened in this circumstance? And I appreciate it certainly has potential for some problems, but what's the difference between this and when there's another type of a case in which family members, support of family members come in very clearly to witness the closing argument and to be a part of that experience? What's the difference here between that and 30 members of a family and some neighbors coming in and being a part of the gallery? This is a public trial. What's the difference here?
Thank you, Justice Rosen. I think the most important thing to consider and remember when considering this situation is that those police officers who entered the courtroom wearing their service weapons and their uniforms and their badges were literally clothed and armed with symbols of state authority. This show of state authority should not be equated with and should not be considered the same way we consider friends and family members wearing buttons and t-shirts. As a display of state power, this was inherently coercive. And remember, Justice Rosen, the trial court didn't believe, oh, this really isn't a problem. Here, the trial court expressed, in a sense, that its hands were tied because the police officers had already made their dramatic appearance. In a sense, these law enforcement officers took control of the courtroom. Now, it's true the police officers didn't act out in any way, but they didn't have to. There wasn't a need for an outburst or a display. They were police officers with uniforms and guns. And let's remember this, no one else gets to do that. No one else is allowed to bring a firearm into a courtroom. That in itself demonstrated to the jurors the power that these police officers have. Now,
Counsel, from that standpoint, when you say it was inherently coercive, that sounds like you're putting it into the supportive bucket. You know, when we're looking at the officers were there to show support, as opposed to providing security, where there would be some inherent notion of the defendant's dangerousness.
Yes, we're not alleging that the appearance of these police officers gave the jurors the impression that Christopher Harris was a desperado of some sort. No, we are saying that the police officers were there to let the jurors know we, not friends of Detective Hill, because remember, they were in uniform. We, as members of the Topeka Police Department, want and expect a conviction in this case. And I would also say that's what distinguishes this case and some of the other cases, like the Schutz case that I cited to the court, from Holbrook versus Flynn. Because you're right, remember, in Holbrook versus Flynn, the United States Supreme Court expressed concern as to the damage that the appearance of a large contingent of police officers could do to the defendant's fair trial rights. But in Holbrook, the Supreme Court found there's really no reason to think that the jury viewed these police officers as anything other than people there providing security. As I stated when we began, trial counsel never said, oh, there's been an overwhelming presence throughout the trial. The security measures are too much. They didn't appear in their uniforms as a group until that moment, or right before that moment, when the jurors were going to switch roles from being witnesses of the trial and consuming in a way the evidence to being the most active participants in this trial, that is weighing the evidence and making decisions.
Let me ask you another, and this is a procedural, and no doubt only a question an appellate judge would care about. I'm trying to figure out which path to put the analysis on. Is this a denial of a motion for mistrial, or is it a denial of a new trial motion? You argue about it in the context of mistrial, and I think there's an argument both ways, but I'm trying to figure out, there wasn't technically a motion for mistrial because the trial judge kind of cut you off and said I would deny him a mistrial if you asked for it. And I realize it's all abuse of discretion at the end, but how do you view the procedural path that's going to get us to abuse of discretion in the end anyway?
Well, I think that I can't think of the case off the top of my head, but I cited a case from this court to you in the brief that says whether it's a denial for a motion for mistrial or denial of a motion for new trial, if it's the same basis, the court follows the same analysis. And of course, we also, of course, argument that it was adequately preserved for review as the denial of a motion for mistrial, because as you note, defense counsel was saying, can I have a moment to confer with co-counsel? And the judge said, no. Yeah, essentially, the judge said, I'm in control of the courtroom. I'm going to do what I believe is right. We believe that's true. We believe that the trial court had the authority and the duty to control the courtroom. And unfortunately, in this case, the police officers took control of the courtroom.
Let's speak to that a little bit. This was a criminal case involving shooting and an aggravated assault of 2 law enforcement officers. And I assume throughout this trial, there were uniformed officers who testified, who were sitting in the gallery, maybe waiting to testify, or maybe they were sequestered. But the jury was familiar with law enforcement officers in uniform being present in the courtroom who were a part of the case. So what is so inherently prejudicial about that appearance of law enforcement being in uniform? And coupled with that, how many of these who were there at the end were witnesses in the case? Do you know? Or because there was some discussion that some of these people are witnesses. Or some of these officers are witnesses, and that's real typical that they show up at trial.
Right.
That's not unusual. So speak to both of those.
And our experience with witnesses, both police officers and civilian witnesses who come to trial, is that they wait for their turn to testify, and then they might come in and testify, and they might wait for a while and watch as the testimony unfolds. They might come in and out by themselves. This was the appearance of an entire group of law enforcement officers. I don't think anyone would seriously believe or argue that they all coincidentally appeared at the courtroom door at the same time, all dressed for work right when the parties were going to begin closing arguments. They were clearly organized to come in as a group and send a message to the jurors in this case.
But there's no evidence that they were there as a command, as some sort of a mandate from their command structure. So get us over to what evidence is there of prejudice?
I think it was just inherently coercive. I can't point to a juror who said, I felt scared, I felt threatened. But let's think about this for a minute. I am not suggesting that the jurors thought, oh my goodness, we're going to be shot if we vote to acquit. But in addition to the badges, the weapons, the uniforms, the police have computers, and they have our car registrations, and they have our driver's license information at their fingertips. It certainly occurred to me, and I imagine it also occurred to the jurors. Police officers.
Ms. Wilson, let me ask you real quick. How do you explain the acquittal on the aggravated assault of officer? Because it seems like they weren't so intimidated that they couldn't, give an acquittal on that.
Yes, Justice Standridge, they did acquit on the charge relating to Officer Jenrette. And as I noted in my brief, there just wasn't any evidence to work with in that case. Officer Jenrette came upon the scene when Mr. Harris and Detective Hill were already engaged with each other in shooting. And he said, I just started shooting too. Mr. Harris clearly didn't even know he was there. And
doesn't that just prove the point that in a situation where there's no evidence, the jury acquitted, but in a situation where there was evidence, the jury found the defendant guilty and wasn't impacted by the presence of because it seems like under your argument, what would happen is even if there was no evidence, they would be so intimidated, so overwhelmed, they have my driver's license, et cetera, that they would find guilty on all charges.
We don't suggest there was no evidence to support a conviction with regard to Detective Hill. What we do suggest is with regard to Officer Jenrette, there really wasn't a lot of thought that had to go into it. In the case of Detective Hill, there was a much more nuanced decision for these jurors to make. Did Mr. Harris know, or should he have known, that Detective Hill was a police officer as opposed to some stranger who followed him in an unmarked car, not in uniform, who accosted him and then shone a flashlight in his eyes? In making this nuanced determination, there's much more room for coercion and intimidation to exert its influence either overtly or subtly. And by subtly, what I mean is this: you have jurors who are looking at that sea of police officers and they feel a pressure to convict, and they take any path that they can to get them to the easy decision, even if that means their definition of reasonable doubt suddenly becomes very, very narrow. So I think there is definitely a difference in the decisions these jurors had to make with regard to Officer Jenrette as opposed to Detective Hill.
Counsel, why would jurors feel a pressure to convict? Your argument is the juror is sitting in the jury box, sees law enforcement, and immediately thinks these law enforcement officers are going to break the law to harass me if I don't do what they want. I mean, isn't that your argument? And I just don't see why a juror would think that.
Well, the jurors who sat on this Shawnee County jury may have had very different experiences with law enforcement officers than you have had, Justice Stegall, or frankly, I have had.
Wouldn't you have to have something more than a bare allegation to rest your argument on, that a juror would immediately think that this law enforcement officer is actually going to violate the law if I don't do what he or she wants?
If you are pointing out that there is no juror that came forward and said, I was pressured to convict in this case, that is absolutely true. It's our position that the atmosphere was inherently coercive.
I understand, and I'm just trying to get some clarity as to, I guess it's true that you're just asking us to presume that the presence of law enforcement is coercive. And it's coercive to violate the law, as opposed to, arguably, why wouldn't presence of law enforcement remind the jury of its duty to follow the law?
If you're suggesting that the police officers who came into the courtroom as a group in that manner were there to say to the jurors, you be sure to give Christopher Harris a fair trial in the accusations that he shot and wounded our colleague, I just have to disagree with you.
Why wouldn't officers want to send that message? I mean, why wouldn't we presume that our law enforcement officers want defendants to have a fair trial? And let me offer an alternative rationale for their presence, which is mere support of the victim in the case, as opposed to attempting to unlawfully coerce a jury, which is a strong allegation, which I don't see anything other than just a raw allegation here.
They could have shown their support for Detective Hill by appearing in their street clothes.
Counsel, do you know, had there ever been did the law enforcement officers appear in their uniforms, including their sidearms, when they testified?
I don't know. That's not in the record.
Do you know whether there was any objection to them appearing in the courtroom in uniform with their sidearms?
At the very, very beginning of trial, the defense counsel noticed one or two coming in uniform to watch, and defense counsel said, I don't object if they come in street clothes to watch the trial. And the judge at that point said, I've only seen one person. I don't think it's a problem at this point, but I'll keep an eye on it. And then nothing of that nature happened until the very end of trial. There didn't seem to be any trouble until the end of trial.
This concept of inherent prejudice is a doctrine that doesn't have a lot of track record in our mistrial precedent. Can you tell me how it fits here and sort of its parameters in the context of a motion for mistrial?
I'm sorry, I didn't quite understand the question.
Well, my understanding is that you're relying on this doctrine that of presumed or inherent prejudice. And I'm suggesting that I don't think that we have any track record of applying that sort of doctrine to a mistrial motion. So I'm trying to understand how it fits here, where we're typically looking for a showing of actual prejudice.
Well, I guess I haven't found any case like this in Kansas, but I did cite to this court the case of Schutz versus State, which is amazingly similar when you think about it. The fact pattern of the underlying offense is very similar. The question of whether the defendant knew the police officer was a police officer, the appearance of the police officers at the end of the trial, some in full uniform, some in work clothes that identified them. And the court noted, the clothing in this case is actually a feature of the case. In Schutz, the Florida appellate court didn't say, well, we need evidence of one juror, of two jurors, of several jurors saying they felt intimidated. The court said this is just inherently coercive. And I would just return to the special place that police officers have in our society, granted by the state, that gives them a great deal of power and authority over all of us. And I would just rely on that.
Are there other questions? Thank you, Ms. Wilson. Mr. Elschlager?
Thank you, Your Honor. I have to give credit to my opposing counsel for her very dramatic introduction and description of the events that we're talking about here. But the truth is the record just does not support her dramatic narrative. There is no evidence in the record of this grand dramatic entrance by the police officers. We also don't know actually exactly how many officers there were. We don't know exactly how many were in uniform or weren't, how many had their weapons and so on, how many were witnesses and how many were not. The only facts that we have are the ones that are found in the trial court's denial of the motion for new trial. So the district court judge.
Mr. Elschlager, we do have the court's immediate response to this, and I have it here. It's counsel, it's too much. If it were a sex case with a child victim, I require any person with any display of sympathy to be removed. I know this is a heated case. It involves an officer shooting. And so it seems to me that at least from the initial reaction of the court, there was a concern and that the court felt boxed in, that they couldn't ask them to be removed without creating some sort of additional tension to what she perceived as a problem. I mean, that's what she said, and that's how she reacted. And how do you respond to that? I mean, there was a concern that this was some sort of orchestrated attempt of something, or maybe not that, but at least the concern about it showing a sympathy, and if it were a different type of case, they would remove these people.
Well, certainly, but once the court had a moment to consider the situation and to reflect on it, then especially when the court actually put pen to paper for findings of fact, the court noted that it was not nearly as dramatic an event as opposing counsel would have you have you believe. I mean, the court wrote in response to the defendant's motion that defendant exaggerates the number of officers who entered the courtroom and the effect it had on jurors in the proceeding. Said that those who entered just before closing remarks did not fill the entire courtroom gallery. They sat quietly on the half of the gallery behind the state. There were no greater than 15 to 20 officers that walked into the courtroom at about the same time. And I think this is key. They entered at a time when there was a natural transition of the proceedings. The court had just reconvened the jury and was getting ready to instruct the jury and hear closing remarks of counsel. There were no outbursts, no overt physical displays by officers. There was no overt staring down on the jurors. About half were in uniform and about half were not in uniform. And I think some key elements there. One, she said they came in at a natural transition. So they actually came in at a point in time so as not to disrupt things. So it was a natural transition in time. And it was at a time when you would think that they would be most interested as spectators. It was right before closing arguments. Also, she said a number of them were witnesses. And I went through the record and counted up, I believe I noted in the record, 13 police officer witnesses. So, I mean, if they were all the witnesses, that just about includes all of the ones that allegedly walked, or that the number that walked in at the time. And that makes sense because they wouldn't be in the courtroom before they testified, but they would be very interested in coming in and watching the end of the trial. And what I think is really critical here is there's no evidence. I mean, we're making a logical leap here. There's no evidence that the jury saw them, acknowledged them, or drew any kind of inference at all from the police officer presence. There's certainly no evidence that they were intimidated by them. And as the court has already identified, the fact that they acquitted the defendant on one of the charges of ag assault against a law enforcement officer really belies or refutes the suggestion that they were intimidated by the policeman. The obvious inference from the policeman coming in is that they were interested in seeing how the trial turned out because their friend and coworker was the victim. And I quoted in the brief multiple cases of different appellate courts presented with the same issue, saying basically, if you shoot a cop, you shouldn't be surprised that cops are interested in the proceedings and will be in the courtroom to watch as spectators. And all the evidence in the record indicates that that's all they were doing. They were there as spectators to watch a trial that they were interested in because their colleague was the victim. They wanted to see how it turned out, and they didn't engage in any outbursts or anything like that. It's a public trial. They absolutely had a right to be there. And it's really no different than the cases that I cited in the brief, a couple of Kansas cases where we had family and friends supporting the victim of a crime, showing up in one case with buttons with the picture of the victim, and other case it involved a DUI, a vehicular homicide case where large numbers of mad and sad, mothers against drunk driving, students against drunk driving, supporters came in wearing obvious clothing, stating their support. And
may I interrupt very quickly? First, I understand what you're saying, and there is a difference, as Ms. Wilson pointed out, that these are state actors. But would you agree that it would have been a better practice for them to come and support without their uniforms and guns?
Well, what would be a better practice, and what is? Sure, it would be. It'd be a better practice if they, came in civilian clothes. I don't know how many of them were authorized. So I don't know how many might have been on duty at the time. We actually don't know how many were in uniform, how many were in plain clothes. Again, a lot of them were witnesses, so the jury had already seen them and as witnesses, seen them in uniform and knew that they were police officers. So, well, yeah, I suppose if they had the option to show up as anonymously, yeah, because it'd be easier for me because I wouldn't be having this argument right now. But yeah, sure, that'd be better. I don't know whether they had that option, and I would say it's not a requirement. I mean, it's a public trial; they have a right to be there. It's during the day, and in all likelihood, many of them were probably on duty or on call.
But they were cloaked there with state authority.
Well,
So
that's what
that's
the opposing counsel says. Although, I mean, I don't think that you necessarily have to. You can't assume the jury draws that inference. I mean, my inference would be, well, they're interested in the trial. They're just watching. They're just spectators. There's no evidence to suggest that they were there to intimidate the jury or send any kind of message. They weren't sending any.
No, I'm not talking about intent. I'm just
No.
talking about impact.
Well, and there's no evidence of any kind of impact. The interesting difference that I remember reading in the Schutz case, which I would first submit is an outlier among all of the cases involving this issue. I know we cited many cases in the brief where the court said, well, that's just not inherently prejudicial. There's no problem. But the one thing about the Schutz case that is different is I believe Schutz actually provided affidavits from people who were in the courtroom that said, this is the impact, this is what we saw, which provided a record from which you could make the conclusion that opposing counsel wants to make here. The record here doesn't have that. The record, it is the defendant's burden to present you with a record that affirmatively shows error, that affirmatively shows an abuse of discretion. And that record is not here. What we know is that as a number of police officers entered the courtroom at a transition period, they sat down quietly behind the state side of the courtroom and they watched. That's all we have. And
Counsel, are you saying that it would have been the defendant's burden to ask the court to question the jury? And if so, when?
Not necessarily. I mean, that would have been one option. It certainly is a defendant's burden to create some kind of record from which the court could find error. How the defendant does that is, there's myriad ways to do that, but I would submit in this case, the record simply is not there for you to establish an abuse of discretion. You would have to stack inferences upon inferences. You would have to infer that, first off, from the cold record, you would have to basically infer the dramatic, intimidating entrance, complete with the Darth Vader Star Wars music that kind of are implied by my opposing counsel's description of the events. And then you would have to infer that the jury actually saw them, and you would have to infer that the jury inferred something from them. The US Supreme Court said in Holbrook v. Flynn that the most common inference that the jury would make from seeing police officers in the room is no inference at all. People are used to seeing police officers. They're used to seeing police officers in the courthouse. They have to pass through security just to get in. There's police all over the place. The fact that they have firearms is also relatively meaningless. The public is used to seeing police officers with firearms. They always have firearms. So what? There's nothing in this record from which you could infer that the jury, there's nothing in this record from which you could conclude the jury was intimidated by the police officers. The dots that you would need to connect are simply not there. And it's the defendant's burden to present you with a record that shows error. And they haven't done so.
Well, counsel, you keep saying we don't know the number. And we do know from the district court's rulings that there were 15 to 20 officers that walked into the courtroom, and about half of them were in uniform and the other half in plain clothes. We know that much.
Yes, we have a range.
And that's about what, and that's really the same, frankly, as the affidavit evidence in Schutz. That all that did was establish the number. Now you had a much higher number in the Florida in Schutz of officers that were there. But so we have those parallels that we can make an argument from. So I do think we have some things from the record. I want to move you real quickly because I'm watching the clock. And when I read your brief, I want to get you over to the instruction prosecutorial error question. You kind of danced around it in your brief, but we can agree, can't we, that the second-degree attempted murder charge that we had prosecutorial error in misstating the law, because there's not an element in that offense of knowing whether the victim is a law enforcement officer, which is what the prosecutor said. I realize you went to harmless real quick on that, but we can really concede error on that, can't we?
Well, I don't want to concede error because I don't think the prosecutor, while reading the record, it may sound like he said that. I don't think the prosecutor was stating this is an affirmative element of the offense. What he was trying to do was distinguish, first degree premeditated from attempted capital and second degree from the higher two offenses. So he was identifying the two elements of the higher offenses that were not present in attempted second degree murder. The way he said it, it does, as you say, it could lead one to think that, well, he was stating an affirmative element, because he said you have to find that he didn't know he was a police officer and that he didn't premeditate. But I think when you read it in context of the whole discussion of the elements, what he was doing, and I think what would be clear to the jurors, was he was just distinguishing it from the other two offenses by identifying the elements that were not present. The verbiage he used was, typical of spoken language, was imprecise. But I think then, if you do, go beyond that, you look at the actual written language and the language of the instructions, the jury was properly instructed. So to the extent that if you believe that the prosecutor did misstate the law, well, the jury was then properly instructed by the court and given the proper written instructions with the proper elements, and that would mitigate any misstatement by the prosecutor and render it harmless. So I know I pretty much just regurgitated my brief to you.
I'm telling you, when the prosecutor says that the lesser included of attempted murder, intentional second degree, to find the defendant guilty of that offense, you must find that the defendant didn't know he was a law enforcement officer and he didn't act with premeditation. I mean, that's a clear misstatement of the law.
Read in isolation, I completely agree. The only pushback I'd give you is I think if you read it in the context of everything he said prior as he read through the elements, what he was telling the jury is these are the two elements of attempted capital murder that you don't need to find for attempted second degree murder. The way he said it, not the best, sure. But I think you could, I can make the argument with a straight face that in the context, the jury understood what he was saying and it wasn't error. But regardless, I would fall back on the fact that the jury, the actual instructions given to the jury by the judge were correct. And, the jury was fully aware, was told that arguments of counsel, not evidence, and not the law, that the law comes from the judge and the judge instructed the jury properly. Okay, and if there are no further questions, I guess I will submit the other issue on the brief, unless there are questions about that. And I would ask the court to affirm the district court and affirm Mr. Harris's convictions.
Are there any other questions? Okay, thank you, Mr. Elschlager. Ms. Wilson, you reserve 2 minutes.
Thank you, Your Honor. Mr. Aislinger has mentioned a couple times that we don't know if the jurors saw the police officers who came in. When the court was contemporaneously reacting to the appearance of the police officers, this court might recall that the trial court said the jury has seen them, because the trial court was concerned that there wasn't much she could do to remove them from the courtroom at that time. And in her written order, I will say this, she mentioned some were in uniform, some were not. She did also say all had their service weapons and all were identifiable as police officers. With regard to the question that Justice Biles had, volume 13, page 910 through 911, the phrase was, to find the defendant guilty of that offense, you must find that the defendant didn't know he was a police officer. And the prosecutor said that not once, but twice, once in the context of intentional first-degree murder and once in the context of intentional second-degree murder. We basically concede that with regard to intentional first-degree murder, this is probably harmless because it was a fair distinction between capital murder and first-degree murder. But with this misstatement of the law with regard to second-degree intentional murder, if the jurors determined that Mr. Harris knew Detective Hill was a law enforcement officer, this erroneously took consideration of unpremeditated but intentional second-degree murder off the table. And if there are no other questions, we would request that this court find that Mr. Harris was deprived of a fair determination of his guilt, or in the alternative of his level of culpability, and grant Mr. Harris a new trial.
Are there any other questions? Thank you, counsel. Thank you to both counsel for your arguments today. We will take this appeal under advisement. Court is now in recess until